The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised. Welcome everyone back to your favorite cubbyhole on the internet. And it's been a busy Tuesday. Yes, it has. Actually, it's been a busy few days beginning Halloween. A lot was filed on the 31st. I don't know if there was something in the water or it was a full moon on Halloween, but much has happened. So let's get right into it. I'm not going to worry about being camera ready, so we're going to do this the old-fashioned way and just make a good old sturdy video for people to enjoy at their leisure while we're waiting for some news of what's going to happen in San Francisco tomorrow or today, depending on when you listen to this. So let's start with our very first document. This comes to us from @Clayton'sJustice on Twitter X. We call it Twitter because we like tweeting. I don't know about Xing on X. I don't know what it is. And this is great news. It's not surprising news, but it's official news. The amazing Emmy Award Winning hot bench Rachel Juarez has made an official appearance in Owens v. Marraccini. And the document to the court says, please take notice that Omar Serrato, Eagle Law Firm, hereby associates Rachel Juarez, etc., as counsel of record for respondent in the above entitled action effective immediately. Omar Serrato remains lead counsel, and attorney of record Rachel Juarez is authorized to receive notices, file pleadings, and appear on behalf of respondent in all proceedings related to this matter. All future notices, pleadings, and communications should be served on both attorneys at the addresses that are very carefully redacted. We could talk about other things being redacted, like David Gingras having that he was a lawyer, telling the cop when he was arrested for his DUI that he's a lawyer multiple times, even though it was redacted. Why? I don't know, because we know who David Gingras is. But whoever redacted it decided to redact that David Gingras is a lawyer. We'll talk about him. I made a thumbnail for it, and I thought about going live last night. Just wasn't in the mood. You know, sometimes you just have to curl up in a blanket and keep warm. That's what happens. That's what happens this time of year. We'll cover that as a future episode while we're waiting for other things to happen. Because we've got it, we're ready to go on that. So our next document. It's not about David Gingras. This was a request filed to the court in San Francisco from Cheryl Lamothi, I think it says. It's small and I can't make it bigger. And I'm told this is someone from Inside Edition who is requesting media access during this hearing. Unfortunately, that request was denied yet again by Judge Carolyn Gold. It's okay. There are people on the scene, and they will be reporting for us as information becomes available on Wednesday, tomorrow. So that's a quickie. There's really nothing more to say about that one. So we can close this one out. The next is a request from Colesrud Law Offices wanting to modify the conditions of release to allow for travel to San Francisco. Defendant Laura Owens, by and through undersigned counsel, respectfully moves this court to modify her release conditions by allowing her to travel to San Francisco from November 4 through 6, 2025 to attend a civil court hearing. Ms. Owens is required to appear in Owens v. Marraccini, there's the case number, at the San Francisco County Superior Court on November 5th at 9 a.m. Ms. Owens is the petitioner in that matter and is required to attend. You got that right. Now let's see if she actually does. Counsel for the state didn't have any objection. The victim's rights thing was pending, but they request the court just go ahead and let her do it, and I think they have. So there's the official paperwork that Laura Owens can, in fact, travel and be present on Wednesday, tomorrow. And we're all taking bets. Will she? I think we might find another excuse, but she may surprise us all. She may surprise us all and actually show up because Colesrud Law Offices made an official filing. That puts her feet to the fire a little more than just, oh, Judge, I need more ADA accommodation. I need more. I need to delay this indefinitely, Judge. And that's what this document is here. So in the following days, I don't know if it was while we were riding horses in Scottsdale over little 2.5-foot high kiddie fences and stealing gold medals away from children, that we had time to make another bitch fest to the court in San Francisco that we aren't getting properly ADA accommodated and that we need more time. And when we were told, no, you're not getting more time, we filed an appeal to the Appellate Court in San Francisco and complained how the lower court wasn't giving us what we wanted. And so the Appellate Court responds thusly. The petition for writ of mandate and request for immediate stay are denied. So not only did we complain to the Appellate Court, we also filed for an emergency stay to prevent the proceeding from happening. The challenged order states that petitioner herself requested a continuance of the hearing until November 5th of 25, but the petition does not address this portion of the challenged order. There's case law there. Liberty's failure to address basis for the court's ruling constitutes a waiver of its appellate claim. When a court states multiple grounds for ruling, appellate addressing some of them, we need not address appellate arguments against one. So really, if there's only one good reason, that's good enough. But Laura, not knowing how to do things, didn't do it properly, and probably just made a medium blog-sized bitch fest about how she was being discriminated against and how her disabilities prevent her from attending in person. Although we could perfectly attend riding horses and jumping things while we're at death's doorstep. Oh, life-threatening medical problems. Oh, you need to not have me be in court, Judge, because I may die. Oh. It's fake, like most of the rest of her life, quite honestly. That's my opinion. I believe she's fake. I believe really her family's fake. Ron had some low-level fame on radio station. Mom had even lesser low-level fame on a little bit of radio and a little bit of TV, supposedly. I sometimes wonder if some of the claims on how much Ron Owens made, if they're actually true. There doesn't seem to have ever been any money, because no one seems to know where it all went. It's suspicious. The writing continues. Moreover, the petition lacks an adequate record. The petition contains a lengthy recitation of alleged failures by the respondent Superior Court to comply with the Americans with Disabilities Act, but petitioner attaches no exhibits documenting the events described. So we make a lot of false allegations, a lot of self-reporting, and we don't back them up, as only the fraud of Laura Owens could do. Oh, I was pregnant. Just believe me, Judge. Wink, winks. Can I show you my fake pregnancy belly? Wink, wink. Par for the course for Laura Owens. So, will she or will she not show? That is the question on everyone's mind. And we will have to wait till the morning. And we will be waiting with bated breath and pins and needles and all those things. So here's a record of the action. And it just says pretty much the same thing as that previous document, and that's dated the 4th of November. And let's see, and it was before appellate judges Humes, PJ, and Smiley J. That's kind of funny abbreviations. I'm amused. So someone's attempt to delay and stall and postpone, probably indefinitely if they could, has been denied. So we must appear or face consequences from Judge Carolyn Gold. What else do we have here? Oh, let's see. More things. Let's see. Case information. State of Arizona versus Owens. And it's sort of a minute entry, and there was a motion on Monday. I wonder if that was the motion to file for leave from the state. That would be my suspicion if it's associated with the criminal case. And speaking of other motions and criminal cases, let's go back to Owens v. Echard for just a moment. For those of you paying attention to the case, or perhaps not, or should say cases, there's multiple cases. We can go back to the beginning of October when Greg Woodnick for Clayton Echard made a motion for supplemental proceedings, and that was for a judgment debtor examination. And that examination is to have the court evaluate what Laura Owens has as her assets so that she can fulfill the judgment issued against her in favor of Clayton Echard to the tune of nearly $200,000. That was the judgment issued by all of the courts, including the trial court, the Court of Appeals, and the Supreme Court of Arizona, for all of the appeals that David Gingras, on behalf of Laura Owens, tried to file to overturn the lower court's ruling, which, as we know, failed miserably. All those appeals required responses from Clayton Echard's counsel and therefore incurred substantive additional cost, nearly, I think, $50,000 worth of substantive additional cost to respond to those appeals. So this is a process by which Clayton's counsel, Greg Woodnick and company, can start pushing the courts to evaluate Laura Owens' financial standings, her assets, and start getting her to liquidate things so that she can start to fulfill payment on the judgment. There is further documentation that is available on victimsoflauraowens.com, which tells us a little bit more, and it's a referral to a civil commissioner. The court has received respondent's motion for supplemental proceedings, judgment debtor examination filed on October 6, 2025. It is ordered that respondent's motion for supplemental proceedings, judgment debtor examination filed on October 6, is being assigned to Commissioner Albrecht for handling. All parties representing themselves must keep the court updated with address changes, and there's instruction on how to do so. So already, the financial chickens are coming home to roost with Laura Owens. As I click to the next thing, which is just another entry in the criminal docket about her filing for going to California. We know about that already. So now we start getting the Laura Owens Roto-Rooter exam into all of our finances, and she has to respond. That time is probably quickly elapsing, and she's got to have financial statements. She's got to have pay stubs, any income she was receiving in any fashion. She's got to present to this commissioner for evaluation so that her financial obligations to Clayton Echard can be considered. Oh, how it sucks to be Laura Owens. And as many have recently discussed in the last couple days, talking about Laura's energies and her motives and her modus operandi internally, it's most likely she's not going to get the message. All of this could end faster, but she wants to continue to put herself through this unnecessary pain and suffering that only she is putting herself through. And she does it for all of the bad reasons that damaged people such as her do. Control, mental issues, family issues, parental raising issues, things of that nature. Family system stuff, all of the above. If she doesn't appear tomorrow in San Francisco, it's going to be bad for her. And it's only going to add to her problems. There are rumors. They are unsubstantiated. Well, they're not entirely unsubstantiated. I can't say that because I know who said them, and I know who said them to whom and about what. I can't necessarily reveal all of those things, but I do know there is a chance, a very good chance, that Laura Owens is being investigated on larger scope grounds, not just on a state's basis, but possibly. And this is just a little bit of personal speculation that could be supported by some things my fellow content creators have let slip, that there could be some federal things coming her way. Nothing has been officially filed to our knowledge, so again, that is somewhat speculation, but we have good reason to believe that there may be more for her yet in store. It could even be other men. I think Greg Gillespie's restraining order situation is on the cusp of needing to be examined as well. So this continues, folks. This continues until she's in prison and can't do it anymore. And hopefully for a very, very long time, if not indefinitely. We shall see if she appears in San Francisco tomorrow. We shall see how that goes, and we hope it goes well. Because this needs to be a good outcome for the victims, all of the men that have been abused by Laura Owens and her family. And it's time to have justice start to enter the picture and do a little victory dance of its own. And we're here for all of that. Keep an eye on all of your favorite creators. Hopefully I'm included in that. We'll be watching this as close as we can. Hey Rob will be watching it as well. We shall receive things from Megan Fox, Lauren Knighty, and most likely all of our other friends, probably Bruce and Dave. As things trickle in, it spreads to all of us pretty quickly. We all get around to it. Eventually, within 24 hours, I think, is sort of the unofficial rule. And we'll be talking about it. I may go live tomorrow. I'll see how I feel about it after the news of the day comes in. And we'll just see what there's to talk about tomorrow. If it's exciting, I may hop on a live and wave to my fellow creators via camera rather than being in their comment section. And we'll just see how it goes. And again, our thoughts and prayers to all of the victims of Laura Owens, and especially for Mike and counsel tomorrow. And we'll see what happens. I I feel less nervous about what's going to happen this time as we did 2 weeks ago. That was a little bit nerve-wracking. I think it will be favorable for Mike in the end. And we shall see. And it will be glorious as we all see it together. So stay tuned, folks. You'll hear more from me tomorrow or today. Don't you love that? The dualistic nature of time zones. Alrighty, until then, so long for now.